Thank you, Esther, and thanks for giving me this opportunity to have digital access as a trade union activist and lawyer to all of you. Uh, because in particular this morning, I feared that I was also the victim of an anti-union busting activity. I made special efforts to come to the office. That went smoothly, but when I entered the elevator, all of a sudden, I don't know who, the elevator company or somebody else, decided to block the elevator where I was stuck for almost more than half an hour. But I'm here with you. I'm happy that I can explain indeed what we could do, be it within the framework of this draft proposal for a directive, as well as outside this proposal. Rory, are you putting up my PowerPoint, please? So you you might recall that in our different replies to the consultations in relation to this directive, and next slide, please, Rory, and next to the particular demands that we had in relation to statutory minimum wages, ETUC had basically two further major demands. On the one hand, that this directive would also help to promote collective bargaining via national action plans, as well as by building in some safeguards which would guarantee the respect for the autonomy of social partners and the role of social partners in this whole process. And secondly, next to promotion of collective bargaining, because they are two sides of the same coin, is to end union busting practices. Now, if we look at the proposal, indeed, Esther, as you said, we got some of our issues and demands in the current proposal, but they mainly relate to promotion of collective bargaining. However, the proposal as it stands for the moment, at least from our point of view, falls completely short in relation to stopping anti-union busting actions, be it by government, be it by employers, and maybe with the exception of Article 11, but also that one has shortcomings, as I will indicate later on. So basically, we are only addressing in this proposal one side of the coin, that is the promotion of collective bargaining, and even there, strengthening is and should be necessary. Next slide, please. Because it is necessary, because as we heard this morning already from different colleagues, and I'm not going to dwell on all the examples that I have mentioned here or in my working paper, which you have received normally in advance, anti-union busting is indeed on the rise again throughout the whole of Europe, from the east to the west, from the north to the south. It doesn't limit itself to Central and Eastern European countries, candidate countries, no, it's everywhere. But next to this very company practices, there is also the worrying trend that if we look at the case law of UN, ILO, Council of Europe monitoring bodies over the last 5 years, we see an increasing number of violations which are identified by those bodies. And I refer in particular to the annex of my document, where it's clear that the violations are in the increase in relation to collective bargaining practices, the right to collective bargaining, the protection and the victimization of trade union reps, etc. Next slide, please. And this is worrying. Why? Because some stakeholders, in particular governments and employers, seems to forget that the legal context in relation to the right to collective bargaining and in particular anti-union busting practices is crystal clear. They are firmly anchored and recognized in international and European human rights instruments, and in particular established via long-standing case law. I have listed here the main instruments which are of value for this particular proposal of a directive, but I would like to draw in particularly your attention to the fact that amongst those, there are also some what we could call EU text, and I refer of course to the Charter of Fundamental Rights of the EU, as well as the pillar. And the reason why I want to highlight this is that we might be all familiar with the international text and the Council of Europe text. However, we seem to forget, next slide please, Rory, is that if we look at the EU standards which we have for the moment, it is clear that they are built upon and intertwined with those UN, ILO and Council of Europe instruments, and thus EU legislation has to be interpreted and implemented with due consideration of these international standards. And often this seems to be forgotten. I mentioned on my slide a few articles and instruments where we have such concrete references and to the intertwining of the EU text with the ILO and Council of Europe text. Next slide, please, Rory. Not only the legal context is clear, but as I said, also the case law and the long-standing case law is clear. If you look at the case law of those international and European bodies, there are two elements which we can summarize. One, collective bargaining is a fundamental right which needs to be promoted by actions and measures. Secondly, that governments should refrain, but also employers, from any act of interference. And thirdly, that if we are not able to exercise fully the right to collective bargaining, we miss out, and we are going to miss out also in protecting essential other fundamental rights, not to speak, of course, in the context of this directive, of the rights to fair remuneration. So if our right to collective bargaining is not recognized and protected, we will not be able either to protect sufficiently the rights to fair remuneration. Next slide, please. The second point, which is quite clear, is that next to collective bargaining, that it needs to be promoted and that it's a fundamental right, is that anti-union busting activities are prohibited, and that thus national regulatory frameworks have in particular to look at what I would call four pillars. One, it needs to ensure rapid and effective protection against anti-union discrimination and victimization for any adverse treatment, and that can go also in relation to dismissal, harassment, because victimization and discrimination is recognized as one of the most serious violations of the freedom of association. This has to go hand in hand with rapid procedures, sanctions, of course, and well-resourced enforcement authorities such as labor inspections. A second pillar, which we need to address, is that indeed we avoid the bypassing of trade union prerogatives, in particular to collective bargaining, so that employers are not able to negotiate with other obscure organizations or associations or even groupings of individual non-unionized workers, as we heard this morning that this is still possible. Next slide, please. Third pillar is that we have to ensure that there is sufficient protection against any act of interference by governments or employers. That implies, if you look at the case law of those international bodies, that no blacklisting, no rigid procedures, such as requiring the consent of the employer to set up a trade union, no bribes in any sort of form, no bonuses to non-unionized workers, for instance, but more in particular, not the possibility to establish puppet trade unions or parallel trade unions. And finally, of course, as Nick indicated, it is very important that we allow no surveillance of trade unions, reps and workers by any means possible. And the fourth pillar, I would say, has to do with facilities, a right which is also anchored in all those instruments, that trade union reps have to have the necessary facilities, and thereby it's crystal clear that the right to access to the workplace is a fundamental right, and that it includes also the digital access, especially in current times. Next slide, please. So, given all that, what can we do in first instance via the directive? How can we use this directive as a stepping stone? Well, although indeed the directive comes towards some of the demands and the calls of the ETUC in different respects, I think there is a need to further strengthen and or clarify the text as it stands. The first issue, which is very pivotal, I think, and Esther already raised it, is to correct the definition of collective bargaining. For the moment, it refers to workers' organizations, but it would be obligatory to mention trade unions instead. Already that would be a big step towards avoiding that collective bargaining is done with yellow unions and or any other associations. In second order, we also have to look at the definition of collective bargaining coverage, because for the moment as it stands, we consider it's described a little bit too limited. Second point is that we have to look at Article 4. Again, we welcome the fact, as Esther said, that there is something on frameworks enabling collective bargaining, that member states have to establish action plans, but what we miss is a complete guidance of what should be and could be considered within those frameworks and action plans as concrete measures. So I think the Article 4 needs to be clarified or give guidance in relation to the measures that we could make or identify under these plans. Some of the measures which we can think of course, is ensure capacity building, ensure that all workers are covered by collective bargaining, that there is collective bargaining in all sectors, but also at all levels. Finally, measures also in relation to victimization and discrimination. And I think a first step that everybody should and could undertake within the national context is to make a review of all the standards you have within your country, and to compare it and put it next to the handbooks of case law of the international and European human rights bodies. As you have seen in the annex to my paper, there is several case law still pending and violations are identified. We would already be going a long way if only in the short term those violations could and should be remedied. But next to a review of the regulatory framework, I think we also have to think of how, for instance, we can strengthen the role of trade unions in legislative and policy setting mechanisms at national level. We heard the example of Hungary, where it was a law was adopted unilaterally by the government, but also how we can make better use by international, EU and national funding projects which are available, and to what extent we can use them to promote collective bargaining. And finally, we would also have to look at, or could look in those action plans for setting up procedures, for instance, whereby trade unions in particular would be able to call upon and bring in the international and European human rights expertise of ILO committees, for instance, or social charter committees. Next slide, please. So this all under Article 4. We come then to Article 9 on public procurement. Again, welcomed, but we think that there is some strengthening possible in this text to ensure that indeed companies who do not have a collective agreement, do not respect collective agreements, are not able to benefit from these contracts or any European funds for that matter. Then one of the key articles I would say in the draft proposal is also Article 10 on the monitoring and the collection of data. However, the way it is construed now, we fear that it can be an interference rather in the autonomy of social partners and the outcome of collective bargaining. The reason why we think that is because there is a huge amount of data to be collected at national level. Basically, the way you read it, for us, it comes down to informing member states and thus then later on the Commission of all collective agreements. However, that is not always possible. It's not always wishable from certain of our colleagues, but also we fear, we miss in this proposal why exactly the Commission wants to do this. Just out of interest, we miss the criteria by which the Commission is going to assess all this data to put it into its report, and more importantly, what will be the outcome and for which purpose all this data will be used. Is it, for instance, to use it in order to elaborate further country-specific recommendations, of which we know back in time they certainly didn't go in the right direction. Article 10 also provides for a procedure via the Employment Committee. I think there again, in principle, it looks okay, but it's completely unclear, but also necessary for us that it is ensured that this is done with the full involvement of European and national social partners. Article 11, I already mentioned it, provides a right to redress and a kind of protection against adverse treatment, which is to be welcomed as well. However, it only applies to workers, but not to workers' reps, let alone to trade union reps, and this has to be remedied. And we also need to look to what extent this article, which relates for the moment only to statutory minimum wages, could also be extended to other workers and trade union rights. Next slide, please. Of course, we have asked for safeguards. As I mentioned before, some of these safeguards are to a certain extent accommodated in the draft proposal. But I think there is a need to at least reinforce some of them. One particular aspect could be Article 16 on non-regression. I think there is a clear need to link the quite traditional formulation we have now with a clear reference to the above mentioned international and European rights instruments. But furthermore, and that is something which is not at all for the moment in the proposal, is that we definitely need to integrate in this proposal a social progress clause, which clarifies that economic freedoms nor competition rules can have priority over or are able to infringe upon trade union and workers' rights. Next slide, please. So these are all issues which, if we can clarify them, if we can add them in this directive, we would make a major step already to further protection of the right to collective bargaining and those who do the collective bargaining, i.e. the trade unions. Outside the box or outside the directive, let's say, we see and remind you of two further calls of the ETUC, which is on the one hand a revision of the Public Procurement Directive and other directives which are relevant, and secondly, a clarification of the interpretation of EU competition law. But I missed out on a third bullet point, maybe because it was too obvious for myself. I think what we need within the directive, outside the directive, what we need in addition, and it was already raised by some of the colleagues, is an enhanced strategic litigation strategy. Some of the issues which were mentioned this morning were completely new to me. Some were old standing, but what I miss is that I don't see them figuring or being brought to the relevant international and European levels. In that sense, we will have to think together jointly of a strategic litigation strategy, which can be soft by making the necessary noise as well as by hard litigation. Thank you.
I'm happy we actually arrange a whole litigation meeting, but we've now, if you like, colleagues only have 5 minutes to ask questions. So okay. So thanks ever so much for setting the scene for us. Colleagues,